Hello, I'm attorney Dominic Latino. I own Column Law Firm. And in this video, we're going to talk about emotional support animals so that landlords understand them a little bit and how they can stop the fraud and protect their properties. So before we begin, as an attorney, I'm required to give the following legal disclosure. There is no attorney-client relationship being established with this presentation. So unless we sign documents of representation, this presentation is for information only. This presentation represents my opinion only. I highly recommend that you establish a relationship with a local attorney or call your attorney if you have specific legal questions. I do represent landlords, and I also represent a company called U.S. Service Animals. U.S. Service Animals is a referral service for mental health professionals, and I help them remain compliant with federal disability laws. So what makes a valid ESA diagnosis? Well, first off, the initial consultation must be either made face-to-face or via telephone. There must be two-way communication for the initial consultation, which means it must be what they call synchronous communication. An online questionnaire or doing an initial consultation via email only does not constitute a valid initial consultation. The mental health professional must be licensed within the state where the patient is diagnosed. For example, if I live in Louisiana and I go to one of these sites and I never talk to a mental health professional, and it turns out I receive a authorization or emotional support animal diagnosis letter from someone in another state, let's say Florida, then that means that the mental health professional has practice across state lines without a valid license, and that makes the diagnosis very suspect. The mental health professional must be licensed within the state where the patient is located. After the synchronous communication, okay, the initial communication, and if the mental health professional, assuming that they're licensed within that state, they'll make a diagnosis that has to be located within the Diagnostic Statistical Manual number 5. That's sort of the mother of all mental and emotional disability diagnosis manual. The diagnosis must be found in DSM-5. The mental health professional then, if all that criteria is met, may write a prescription or authorization letter for an emotional support animal to give to the landlord. So what does that letter look like? Well, first off, that authorization or prescription letter must be on the mental health professional's letterhead. It has to state that the mental health professional has an ongoing relationship with the patient and is familiar with the patient. And yes, the initial consultation constitutes an ongoing relationship. It has to be dated within a year. That's evidence of a current relationship. It also helps them, the patient, on another topic, and that's fly with their animal if it's dated within a year. The patient has been diagnosed with a disability under DSM-5. It must be stated within the letter. And it states that the mental health professional is prescribing or authorizing an emotional support animal. And the letter also has to state that the emotional support animal mitigates a symptom of the diagnosis and the disability and helps with everyday functionality. Sometimes it's defined as a major life function, but basically what that means is that they can live and enjoy their home and premises. So what is a landlord's responsibility to an ESA owner? So if we assume that the letter is valid, the diagnosis is valid, and everything's done correctly, the landlord must provide reasonable accommodation. And in this case, it's pretty easy because the landlord has to do nothing but allow that tenant to live with their animal. An emotional support animal valid diagnosis overcomes a no pet policy. The landlord cannot ban the animal because of breed, size, or weight. You cannot charge a pet deposit, pet fees, or pet rent. You cannot use your insurance is going to go up as an excuse. The ESA is allowed on all property common areas, which means, for example, if you have a laundromat on premise, they get to go there. You have a pool, they get to go around the pool. They don't have to go in the pool, but they get to go around those common areas, hallways, etc. And you also cannot require the disabled person to do anything extra. It constitutes an undue burden. Because they've been diagnosed with a disability, you can't, for example, say, well, I require you to have an insurance liability policy in case your animal bites another tenant. You can't do that. Those are the landlord's responsibilities. Well, given all of that and the responsibilities from a landlord, you can see how the disability laws could be fraught with fraud. Obviously, if someone coming in there saying they just want to live with their animal and saying they have a disability. The first thing the landlord needs to do is to understand and know the difference between a service dog and an emotional support animal. I cannot tell you how many times that the landlord gets those confused, and as a result of that, you have a disability claim or a discrimination claim filed with HUD against that landlord. You have to know the Fair Housing Act limitations for emotional support animals. That's actually a good thing. There are limitations that a landlord has to be able to protect their property from someone who is fraudulently claiming a disability that doesn't exist. You have to know what disability discrimination looks like and entails, and the common traps for landlords. Right now, I see a lot of landlords trying to fight back with the ESA fraud, but they're doing it wrong, and they are discriminating, potentially discriminating against someone with a disability. In other words, someone who is disabled is getting caught in the big net, and one day you're going to get hit with a $20,000 fine from HUD, thinking you're doing the right thing and you're not. So you have to know what that entails and how to stop or prevent that from happening. You may want to include, there's some language you may want to include in all your leases to protect your property, and that's all your leases, not just people with disability. You cannot single them out, but there's some language that you can use to help protect your property. Know how to handle an ESA tenant that breaks the rules, what needs to be done, the proper procedures, and and if they damage your property, what you can do. Know how to evaluate the prescription or authorization letter properly. In other words, putting additional burdens placed upon the person with a disability is discrimination, especially if they turn out to have a valid disability. But there are evaluation techniques that you can use to make sure that the letter is done properly. Know the definition of reasonable accommodation and what are exceptions, because there are some very, very narrow, very limited exceptions, but you may fall underneath those. You just have to do an evaluation, get with your attorney or call me. Know all the responsibilities that an ESA owner has to you and to other tenants. So know that. So an ESA owner doesn't just get to live free reign. They have responsibilities as well, and you must know them so that you can make sure that that ESA animal is living and that owner is living up to those particular standards and responsibilities that they owe to you. Okay, and we are going to end with a shameless plug for Column Law Firm. I'm attorney Dominic Latino. I own Column Law Firm, and we've been specifically in the emotional support animal service dog space for 4 years now. We help landlords protect them, save them from thousands of dollars worth of damages, and allow them to collect the pet rent, pet fees, and pet deposits from people that fraudulently represent themselves as having disabilities. We help rewrite leases and implement policies that protect the landlord from discrimination complaints, because if you do it right, you are protected, and you can stop the fraud from happening and protect the rights of those people who truly are disabled. We'll help train your property management staff, if you have them, on how to properly handle reasonable accommodations for emotional support animal. What's the proper way to do it? Give them a checklist to be able to do it if you want us to do that. Now, we also offer a complete soup to nuts system of evaluating ESA, emotional support animal, or service dog requests for reasonable accommodation. As a result of that, we'll indemnify the landlord for our work in separating those that are valid and those that are fraudulent emotional support animal or service animal reasonable accommodation requests. We'll also represent the landlord and take care of any HUD complaints or state agency complaints, because we stand by our work, because we've done this so many times. I hope this presentation helps you. I hope you have a great day, and I look forward to hearing from you.